So about the quiz, I couldn't contact because sir is on vacation, but I marked a couple of ones where you could go for instance, and one. So I have to wait till sir comes ready. The first one is send the answers. The first comment correct, but I will give you guys the yes. But any clarifications to be done? Did you check on? Forward everything else in the website. No, so I have sir has sent the answer. So I cannot make any changes now. There will wait till sir comes because he needs the credentials to change.
Other than changing,
I will ask them to give access to you, like once that's done. Okay? Right. Okay. Then we'll start. So in the meeting's presentation, you must have noticed we had one title on accounting records, but we didn't do the lecture because it was supposed to be a separate lecture. That's why today we are going to focus on that. Okay. Right. Okay. I'm hoping that you all know more about accounting records and financial statements than me. I'm hoping to learn something from you. I'm having lunch now. And then I'll keep a lunch break. Get a lunch break after the next, like after 1 hour. Yes. Some of you have already had your lunch. Some of you haven't. Yes. Anyway, once I finish this one, before going to the next session, I will give you the lunch break. So today we are going to look into the different kinds of accounting records, their goals, what should be included in accounting record, why it is important. Did you finish the lecture? Upload to the library. I'll have to. So usually uploads weekly, is it?
already gave us upload.
All of them.
Which one is the
Anyway, I don't have access to any. That's the problem. So I can't upload it. You have to wait. I'm not sure if I'm allowed to start the presentation, but that's fine. Anyway, I was check with I didn't want to disturb somebody from different questions. But anyway, before the semester comes to an end, you will have all the presentations there. Okay. Right. How come the other batch has the presentation? Anyway, okay, let's focus on this and let's see the big end. Okay, so we're going to be looking into different forms and their duty to prove. Okay, so basically, why do we need to maintain proper records? Why do we do that? Purpose of spending lots of money on training and having confidence in a company. Why do we do that? Tell me why. Why do we need to maintain proper accounting records? Yes, true. The statutory requirement, that's correct. Now asking why? Of course, if something is a rule, you have to follow it. And typically, why do we need to prepare all of these financial statements? What do we do with those people? Right. First is to keep track on the company's business, whether we are going bankrupt or whether we are making a loss. Yeah, that is one reason. Files. Why do we need to take? Yeah, we need to share information with the shareholders. Yes, correct. Anything else? Yeah, based on the information only, they can make decisions for the future. right? But how we want to proceed, whether we want to go on the same track or whether we want to change the strategy. Yeah, correct. What else? Exactly, right? To prevent the company from facing any frauds. That's very important. Otherwise, randomly people will come, make decisions, make some money out of it, and it will just disappear. So, most importantly, frauds. But good, I think you have covered most of the important ones. And I hope the students listening online can hear me. So, the reasons are, one is, of course, we want to keep track of the company's progress, where we are going, whether it's heading towards profit or loss or what's happened. And the next one is we want to share that information with the shareholders or the members who are entitled to know what's happening in the company. And we need to prevent facing from any sort of frauds, any illegal activities, frauds. So that's why we need to accurately maintain the record. So pretty much, I think that's what I explained here. Of course, it is a statutory requirement. So directors should do that. Okay. And what's the purpose of auditing? Why can't we just prepare the statements and keep it? Why do we need auditing? It's done the work. No, money. Why can't we just prepare? Yeah. That's a yes. Yeah. Because at the end of the day, we are all humans, and humans do make errors, right? So to make sure there are errors, and of course, when it comes to when we only do it internally accounts, it's very possible that if there is no check and balance, we could do frauds because no one's going to get caught because we know no one's going to check it. So it's to make sure there's a check and balance, to make sure there is accountability for the people who prepare it, we need to have auditing. And what's the purpose of having internal auditing and then external? Yeah. Why do we need that?
They call
Yeah, of course. First one is, of course, we get an independent inquiry of whatever that's happening. But more importantly, this is to get a third person's perspective into what's happening inside. Because if someone's been doing it for a particular period of time and doing it, there can be chances here they will not look the mistakes into. They will not find it because it's become a practice. Maybe that's there for a long time. They will look into. But when you go for an external one, they will in every different aspects. And it's their job to find these errors and inform the company. And of course, to prevent frauds, right? It's important to have that internal and external check. Right. So the meaning of accounting records has changed a lot over the years. Earlier, back in the days, probably in 1949 and all, it was all in books, right? Written record books, lots of books, everyone were doing. And with, yeah, first and probably I think calculator was there. So they would, yeah, anyway, right? But now it has evolved into, later it came into spreadsheet, Excel sheets, and nowadays you all use software, right? Yeah. Do you all learn about Excel spreadsheet formula and software or just the software? There can be companies who can't also have these customized software. Probably they will go for spreadsheets, right? At the beginning, and it's the small scale. So in the case of Team Canada versus Health in the Sri Lankan case, they said proper books is not something that is defined, but wherever it is made sure it is properly done, it is maintained in a periodical manner, and it contains all the contents that is required by the law. It is a proper accounting book, right? So there is no requirements as to how it should be, what means it should be presented. Okay, so what's the purpose of making it mandatory? we looked into the reasons what will happen to the company. On the other hand, we need to look into if things go wrong, what will happen. For the key things right, we need to maintain it, but we need to make sure we need to make the directors who do that job accountable for their actions. Because based on that only they are making decisions. If the data is wrong, the decision made based on that will also be ineffective or wrong. So it's more important because at the end of the day, they will all become personally liable for their mistakes. They cannot say I did it and they cannot say it's the company's fault. They are personally liable for any mistakes. And what is liquidation? Learned about it? Yeah. Step before that, before winding up, what we need to do? Make all the answers and everything. You need to get the budget into money and pay all of creditors, collecting everything and finish it off. The winding up is the end process. Before that, when company goes in insolvency or it goes to a stage of liquidation, then the go to this thing. So if that happens to a company, it's very important that we need to check the accounting records. We need to see why this happened. Is it because of the mismanagement of the directors? If they made wrong decisions based on the accounting, if there is any inaccuracy in the data given, right? If they have believed that data and made decisions thinking that their company is getting profits, but actually they were not making any profits. So it is important that we check that. So this is in a negative way we are looking at it, right? We can prepare the company, we can look at from frauds. This is the positive way of looking at it. But if things go wrong, what will happen? The directors will be held accountable, not only within the company, but even at the court of law, because you can't file actions against them. Because as shareholders, you trust their decision. You invest money trusting that they will make the right decisions for the company. And if it can go bankrupt, if they have done fraudulently, if they have acted negligently, if they have made decisions based on inaccurate data, then they have to be found personally liable for their. So that's why it's important that the accounts should be maintained properly. Okay. So of course the form of accounting records are so diverse. I think different. The basics foundations are similar, I believe. Like you all must have learned different forms, how they are calculated. And I've never seen a software, but I'm assuming everything will be there. You just have to enter the data. Right? The format and everything will be there. Okay. So I'm assuming that will be the case. So financial statements can be easily created through that. Is it like an SQL query? Similar. You like enter data and like want to like quarterly report. It will generate report, isn't it? Those softwares. Okay. Right. So I would expect you to actually remember this one section for accounting records. That's 148. So 148 subsection 1 will talk about the 4 different formats that we use. And 148 subsection 2 is about what should be included in a company. Okay. So give me an example of an entry where a company receives money and then pay money. Think of like a shop or a company that is manufacturing or any kind of business. Can you give me an example of an entry? Where a company receives money. Yeah, selling goods. And what about paying? When they just like the entries that you enter in your statements. Yeah, what kind of? Yeah, that is you pay electricity, water, right, etc., all of that. And of course, when you purchase goods, that also comes here, right? Okay, assets and liabilities. What kind of assets are we looking at here? Give me an example of asset. Okay. Yeah. The machine. Yes. Land, buildings. This is like basic grade 9 commons. Right, liabilities. Okay, so these are the different kinds of entries. And we also have to make a record of the goods that we bought, that we sold, right? Of course, we will have them in separate records. We will not have everything in a messy one, but we will have separate records for each of them. We will have the details of any of the invoices we have received, the ones we have given. If they have any, even the company still has some shares and stocks. If that's there, you have to maintain that. If at the end of the year, if you have a amount of stock in your company, in your shop or whatever, you have to keep a record of that, right? So that's the content of accounting record. The next one is location. But it's obvious we can say if the company is in Sri Lanka, record in Sri Lanka. But it says with the permission of a register, it can maintain records outside of Sri Lanka. Can you think of a location where one would need to have accounting kept outside Sri Lanka? Any other occasions where one will need to keep accounting outside of Sri Lanka? Or they have simultaneously maintained in Sri Lanka and then outside. Yeah, maybe the parent company is in another country and it has something here. They will have to maintain records, right? Or if they get funds from different countries, they have to report to them separately, and they will have different mechanisms of when one could ask for 6 months, but once in 6 months, one could ask for quarterly. So they will have to have their accounts maintained simultaneously. But I'm assuming if the software is there, they can just log into that and generate the reports, right? From India to work, as long as they have the credentials. But in earlier times, they have to prepare these statements and they should either mail it or fax it, right? Okay. Alright, so location, that's fine. So as I told you before, it is a legal requirement, a statutory requirement, and the reason is why we need to make the directors accountable for their actions. Right? And is it necessary that the accounting, that the directors need to have some accounting background or knowledge? Do the directors need to have them? No. So if they don't have, then how can we make them accountant? Did you learn about that in directors' duties? So you told me that directors do not necessarily need to have an accounting background. If that's the case, then how can we find them responsible for the act? They don't know. Then what's the expectation on them? Yeah. The marking, let's say there's a director, okay? He doesn't have any accounting background. He doesn't really understand accounting terms or whatever. But he has to make a decision now. And he has made a decision and that has gone wrong. Okay? So now can the shareholders file a case in the court against the director? Say that this director made a decision because of this, the company has gone bankrupt or whatever. Or some mistakes happen. Did you learn this in director's duty? That they have to rely on the expertise and skills and experience of the people from. You didn't do the lesson. That's why I asked. Some of you said you have done the lesson on director's duty. You've done it or not? Because it won't make sense to talk about directors here if you don't know their duties. That's fine. You didn't learn about directors, their appointment, their qualifications. What? Did you study about it or not? If you know, we can learn about it, but just be clear. Yes or no? If you study about it, yes. Yeah. So in that, if you learn about that, no, no. It's okay, but just give me like one answer. Because in the previous class, they told me that they didn't learn about it, so I didn't take lecture to them. Because they had certain from past way. When you can't remember anything, that's okay. Okay, we will have a quick and recap that. I'm not sure because that's very important lesson on director's duty. Anyway, and this is something we talk, right? The difference between a company coming to a cease position as opposed to it becoming winding up. If it's cease, that means it's paused for a moment. So even if it's paused, that the accounting records need to be kept and maintained properly until the point where it winds up, that it comes to an end. And it has to be maintained in a way that at any time you can check it for a reasonable accuracy. Okay, one cannot say like our house is not ready. It will be ready by next week. You have to provide something for that particular period of time. Okay. So all of these recordings must be prepared and maintained in a manner that is stipulated in the Companies Act. So it is a statutory requirement as we mentioned. So statutory obligation means it has to be prepared in a manner stated in the law. Okay. Financial statements. So accounting records is like a broad term, right? It encompasses all kinds of accounting records. Now we are going to focus on specifically on financial statements. So what is a financial statement? It's not a legal question. What is a financial statement? It's like what is financial? It's a statement of financial position. That's a very great and basic answer. So then explain it to me. What is a financial statement? What it will have, like what it will contain. Okay?
So financial.
Question as to like what X, Y, Z. Tell me those regarding what? Will it have every single transaction that happened? Right, okay. Why is it so hard to get such a simple answer from you all? Okay, right? So I'm sure you all understand what a financial statement is, but if it says that specifically if it's a trading company, it will have this big and loss statement as opposed to expense and income statement, right? So all of these need to be properly maintained. So this one you all know, right? It will have balance sheet. I don't spend time on this. Okay, how often it should be prepared? How long? Last time also we discussed the balance sheet date. The balance sheet date. 31st March. Either March or December. Okay. So they are responsible to prepare it in 6 months of the balance sheet date. They have to submit it, and it has to be certified and has to be dated and signed by least 2 directors. And later it has to be registered in the Registrar of Companies. What's the reason for doing that? Why do we need to send a copy to the Registrars of Companies? We learned in charges, right? Charges needs to be properly documented and a copy should be sent to registrars. Why? Why can't we just keep a copy to ourselves and just move on? Right? Changes as well. Yeah, it's statutory account. And I'm asking, like, what's the purpose of submitting it to the registrars of companies? Alice, the reason when you registered your company, you agree that it will be in compliance with the action order. Even though you prepare it, you make sure that there is an internal audit and everything, you have to make sure it is accountable. And so we need someone else to maintain these records. And in a case that the records get destroyed or get misplaced in your company, then we will still have a copy maintained in another place. That's the main idea. You have to keep a copy maintained separately. Okay? So even if this one gets destroyed, misplaced, or anything, it will still be maintained. So even if there is a forgery, like imagine that there is a forgery, directors are saying now that the software became corrupted or there is an issue, the company caught on fire and no records are reminded. So now how are we going to prove that they made a mistake or prove that they are the ones responsible for this? Because no records are there. Then we can go for the copies that are maintained in the registrars of companies. So law is created in a manner always thinking of the negative consequences if things don't go in the right way. Because if everyone follows the laws and everything is fine, then we don't really need lawyers, courts and everything, because everyone will be following the law. Because this human nature to breach it, to make changes, make errors. So we always consider that if that happens, you can have a copy similar to your deeds, like even in your living in a own house or if you're renting out a house or whatever land or whatever, you will have a document. The person who sold it to you, they will have, and the registrar will, or land registry, right? For your company's registry, that is land registry will have a copy. So even if one gets misplaced, you can go and get a copy from the registry, right? So the contents, the main purpose of maintaining this financial report will give a fair and true view of the company as to where the company is heading, what's happening with the company, where it is at the moment. Okay. So in addition to the laws that we discussed, right, our main purpose in this lesson is to focus on Companies Act. But if it is a bank, then in addition to this level of, because it's a company, in addition to being a company, it also has to adhere to the Banking Act. Similarly, if it's an insurance company, it is a company, so it has to be governed by the Companies Law Act. And in addition to that, it also has to be made by the Insurance Act. Similar to different sectors, right? They also have specific laws and regulations. I told you, it's to give a true and fair view. That's what this particular case is also talking, right? When one particular person overstated the assets of the company because of the misstatement, then the question is whether that gave a true and fair view of the company. So if there is a scenario given to you and if it says that they have overstated the assets value or whatever, then you have to think about maintaining accounting records and what's the purpose of doing that. Okay, so that's where the principle of having true and fair view of the state affairs of the company comes. Have you learned about group of financial statements? Because it's a very new concept that I learned in this particular lecture because it's new. I'm sure you still learn about it. Yeah. It's group of financial statements. Because in the previous class, they actually explained it to me very well. Anyone here? Can you give me an example where a group of financial statements, the need for creating a group of financial statements would arise? Yeah. Absolutely, right? So it comes as where one particular company that is the other ones because it functions as one at the end. It has a consolidated balance sheet. Okay? So I hope that's again a technical one that's clear to you. All right. Lot of repetition. So I'm not going to spend too much time on this. So I'm going to move to the director's duty relating to accounting record. Okay. So I'm going to open the presentation. But are you all sure that you did the full presentation? Directors or not? So you know this? Yeah. Remember seeing this presentation? Yes? Okay. Okay. If yes, then tell me what's the qualifications to become a director? Yeah, 18 years. What else? Is that the only yeah, if someone's got the age of 18, they can become a yeah. They should be mentally sound. Yeah. What else? Yeah. Ah, there is a limit. Good. What else? Sound mind above the age of 18 and should be below the age of 25, the age limit. Unless again they could be proved that they are competent to take their responsibility. That's all. If in a previous lecture someone asked whether an alien can be a member or a director of the company. Alien can. Why? That is saying law that an alien cannot be a right? Okay. Right, so have to be a natural person. That means that person needs to have a legal character. You cannot come up with an imaginative character and make them a director. All right. What about option B? Heard of option B before? That discharge installment. Should not have been okay. Okay, that's the impression I got from the previous lecture also. But this is about that person should not personally be insolvent. If that person, that means what? If that person cannot take care of his own assets and liabilities, he cannot be a responsible person to take care of a company's money, which is direction. But if that person has personally gone bankrupt and if he's facing legal charges for that, then he cannot become a director. Does it make sense? Personally, the person is not responsible with his personal assets, and if he has paid legal charges for that, then he cannot go and become a director of a company. Okay, so that's what undischarged installment means. And of course, it should not be prohibited by the law. Right? Right. And in addition to these layers, option G is about that particular article of association can have its own set of requirements who should become a director. Maybe they could say that person should have been part of the company for a particular period of time. That's not something that is stipulated by law, but the articles of association of a particular company can come up with those requirements for the benefit and interest of that company. Right? Because law is control and tell you everything. At the very beginning also I told you, it's about setting a framework. That's what the Companies Act does. Right? It sets a framework for you to work with, and within your company, you can have your own set of protections and layers of laws. So appointment and also, you don't look like clueless. Like, tell me if you have done this lesson or not. You cannot recall what you learned. Huh? Yeah.
Connect with the foreign industry, government employee.
Connected in the sense, if he is an ambassador.
Foreign and let's say foreign employee.
It depends, right? Being an ambassador, being like a project officer in an embassy, completely varies the power they have. So if he is an ambassador, that is, of course. So you're saying he is an ambassador. So you're saying
Ambassador representing another country.
country. So Sri Lanka. So let's say he's an ambassador for Sri Lanka in Switzerland, right? Okay. So you're asking that whether that person can get elected here. So he's a public officer first, right? I cannot think what to do. Quickly think of an occasion that could be fun, unless of course if he has connections or if he makes any financial decisions for the country. Right? So imagine there are some ambassadors who are nominal. That means they are in that position, they represent us in the meeting in UN and all, but they cannot sign commercial agreements with their country. Right? If they have such power, then I would think they cannot be a director. It depends on their specific set of. But I will double check because this is something I'm assuming because I haven't never checked whether an ambassador could be a director, but I have never seen that happen. So probably that could be the reason. Okay. Right. Did this doubt came to you when sir is the next one? Can you recall sir doing this? No? No. No, I'm just asking because that I had the same doubt when sir is the next step. I'm asking. No.
And I got by that.
You're asked. Oh, fine. So it is established that sir has done the lecture before. Yeah? All right. Okay. Right. So then we'll focus on today's one. Third extinction. Okay. So powers of directors. As I told you, based on the accounting records or whatever, that they have the power to make decisions. The power that is given to them is to actually function and operate independently and flexibly within the company to achieve its objectives. They cannot have their self-interest invested in them. So that's what we are going to focus more in directors' duties. Start with this. Okay. There are a couple of different kinds of duties relating to specifically accounting records. The first one is, that's a common duty as well, which is the duty to act in good faith and in the best interest of the company. Right? Do you know what good faith is? You're hungry? You're hungry? Cooking the time? All right. you had to tell no right now. Anyway, what is good faith? Acting in good faith and best interest of the company. That's competence more or less. Good faith means good intention, right? You act with the good intention and best interest of that particular company where you set aside your own interest, right? You put company's interest before everything. Even if the decision that's going to affect you, like say they're going to cut down the number of directors they are going to have because it's very expensive to maintain, etc. That's going to affect you personally as a director, but that's in the best interest of the company. So you have to put the company's interest over your own self-interest, right? Okay, so that's basically what means good faith and in the interest of company. But there is one important exception to this. That is, when you are a subsidiary company, right? And there is, of course, a parent company to that. In occasions, it is a very exceptional situation where if there are conflicting interests and priority to these two companies, then you can prioritize the parent company's interest over your own subsidiary company where you are a director. Is it clear or confused? So, at the previous slide, what I told you is, in every occasion, a director has to act in the best interest of the company. So, let's imagine there are two companies, A and B. A is the parent company and B is a subsidiary company. As a director of B's company, he has to put that interest at best. Okay, so that's the rule, law. But there is one exception. The exception is when the priorities, when the interest of parent company are conflicting with this one, right? Then you can prioritize the parent company. So let's imagine a situation where B company, subsidiary company is not doing well, not functioning well. So you have to take some action, some specific decisions to either go forward with it, or you have to either wind up. It's not going to work, you have to finish that off. So if you are going to make such huge decision, then you have to think whether that puts the parent company at risk. Right? So you cannot just go ahead and act in the best interest of that subsidiary company because you have to look into the bigger picture. So you have to consult and get advice from people who are working at the parent company, and you have to see what their set of priorities are, right? And they will make a decision weighing the risk, whether it's risky enough or whether they could afford that risk to invest in this company more, or whether they should wind it up and focus on developing the parent company, right? So that is the only exception. Right? In all the occasions, the director has to act in the best interest of the company, but if there is a situation where there are conflicting interests of parent company and subsidiary company, then the parent company's interest prioritizes. They come over this, right? Okay. Do you guys want to have your lunch now, or shall I go forward? Shall we go a little longer? Okay, right. Let's look at a couple of cases. So I have picked some cases. Maybe even sir has done. I have added a little bit more cases. So I think this will still be useful to you. Okay, look at the case of Percival versus Wright. This is an old case. So now we are going to look into a couple of cases how the duty of care that is expected from the director has gradually increased. Okay, So I told you at the beginning, the purpose is for us here to understand the duty of a director. The very first one we learned is they have to act in good faith and they have to act in the best interest of the company. And we looked into a exception. And now we are going to proceed to look into the level of duty of care that they need to follow. Earlier we looked into what they need to do. That means they have to properly maintain the records, they have to be answerable, they have to be accountable, etc., etc. Now we are going to look into how they should do it. What they should do it is fine. It's very technical. It's maths. Basically, they have to maintain it properly. But what's the kind of care they have to give when they do that activities is what we are going to focus here. Okay. So look at Percival versus Wright. In this case, I don't think it's difficult to understand it in simple terms, but in this case, Percival versus Wright. Anyone want to try? Just tell me what's happening here. What happened in this case? Yeah. It's difficult to understand. Basically like a story, right? So what's happening here? The shareholders. Just try. It's fine.
It doesn't.
Okay. Yeah. So then what the court said.
Appreciate it.
No,
Okay.
that's the claim, right? If you read carefully at the very beginning, what's given is the facts of the case. And what the court decided is this. Don't get that too confused. See, because it says the argument was. So I'm sure you must have looked at cases, but look at this, right? Shareholders wanted to cancel share transfers because directors hadn't informed them about the negotiations they had. So basically that they haven't informed them about this third party negotiation. Who? The directors to the shareholders. Is that clear? We have the directors, they haven't informed and they have made a negotiation. So then they are filing a case against the directors. Shareholders are filing a case and their argument is, as trustee, as we trust them as shareholders and the company, they are responsible to give us this information. They are responsible to share, disclose this information to us. They cannot just go ahead and make that decision. So then the court held that directors only have duties and loyalty to the company, not to the shareholders, right? So they do not owe a duty to inform each and every shareholders about their decision. Because at that point, the court tells that it is burdensome for the director to go and explain every single decision that they are making, every single negotiation they are making to every single shareholders. Because imagine if it's like a huge company and it has lots of shareholders with 1%, 2%, 3%, then imagine explaining this to everyone. Not everyone's going to agree, but at some points, directors have to make some decision. So at that point, the court thought, okay, this is the level of standard of care we are going to set for the directors. Directors need to be loyal to the company. They have to act for the best interest of the company, but they are not trustees to the shareholders. They are not answerable to the shareholders. But this has changed over the years. Okay, when you look at other cases, you will understand. Okay, look at this case. Here, the standard of care has gone a little higher. This is something you mentioned, right? Reasonable being reasonable. This is the standard of reasonable care test. So earlier they said, okay, they are only responsible for the company, and if they have made a decision for the best interest, if that's what they think, that's it. They don't have to answer to the shareholders, right? It's more or less a very low standard. But now they are coming here and saying they are setting a standard higher than. They are not just looking into what they have done. They are looking into what a reasonable man, an honest, intelligent man would have done in that situation, right? And if they think if the directors fail in that test, then they will be found responsible or accountable for their actions. So earlier they only looked into their actions. They will look into their actions. Okay, whether that did you do it in your good faith? Yes. If you thought if that's in the best interest of the company, yes. Then they are like, okay, fine. You don't have to answer. But that's a very low standard. Now they are saying it's not what you have done. We are going to put a reasonable man in that position, and we are going to test how that person would have made a decision in that circumstance. If that also results in the director's decision, then fine. If not, then the directors are accountable for their actions. So that's why it says whether such person would believe that transaction was beneficial for the company. So imagine that the directors decided to go for a negotiation, decided to go with a new third party for an action, right? And if that ends up becoming that company becoming bankrupt or in a failure, then the question is not what they did. Even if they have done in good faith, even if they have acted in best interest, then the question is whether a reasonable man would have done it. Okay, so can you see the difference? Earlier it was a very low standard. They were just looking at what they have done, but later it is the reasonable man standard. Okay, and it has gone even higher in the recent cases. So you can see this is a very old case in 1970s, and then you will look into some other cases. So here, look into the disclosure of information. One of the main duties of the director, that they have to be very transparent with their shareholders. So look at what happened in this case. So ex-director is a person who is no longer a member of the company, right? He's no longer a director. So what he has done is, when he was leaving the company, he hasn't expressed his interest. He hasn't disclosed the information and properly documented in the minutes that he wanted his employment to be terminated while getting a payment of how much is that? 100,000 pounds. So then the new management is like, it's in shock because they didn't know it was discussed in the previous meeting. It was not properly documented. So then they said he cannot claim such payment because why? The directors are expected to disclose all essential information to its members to make a decision. So simply him personally having that idea and imagining that he would get that amount is not sufficient. So disclosure of information is important because he should have disclosed his interest. Right. Next one. These cases are not in your to upload the upload. Right, look at this one. So usually in a company, they make some decision as to how their shares should be spent, right? Which portion they should be allocated. For someone would say to maintain whatever the company's current status. One would say it's for its progress. One is for some employees fund, etc., etc. Right? All of this will be allocated in a different manner. So what the directors have done is they have used that particular allotment of shares to a different purpose, right? And now the court is posed with the question whether that decision is valid, whether the directors could do that, right? So Lord Wilberforce, the judge's name, okay? Lord means lordship, judge, not like, it's not name, it's lordship. Like Lord Voldemort, you know, you watched Harry Potter. Okay, so like that, but in the context of a court, we call them judges, and then when they go higher in the hierarchy, we call them lordship. Like in Supreme Court, we call them lordship, right? So he is saying it is correct to say that when the self-interest of the director is involved, right? If their personal interest comes into the picture, then even if they have acted in good faith, that it will still amount to being liable for their actions because they have put their self-interest over the company's interest, right? So earlier they weren't even asked to justify their actions, right? They said, okay, they are only liable for the company. If they thought that was for the good of the company, that's fine. Then became the reasonable man test. And here we are saying that they, even if they have acted with good faith, if the decision involves their self-interest, then that is accountability. Okay, so that's very important where you have to see where they are setting the boundary after standard of care. And of course, you all know good faith. We will look into more cases into standard of care. But in addition to being of acting with good faith, acting in the best interest of the company, to having due standard of care, they also have to act in compliance with the company's and the articles of association. It means their constitution of that particular company. That is a statutory requirement. So, what does standard of care means? When we look into the previous cases, you can see that they were arise at a time where the law was not codified. We all know when the Companies Act was enacted. Yeah, right. So any cases that came before the law of corporate law, company law was evolved through cases. There is no legislation. That means there is no document. So they will look into how law has evolved through cases. Only when an issue comes to the court, they will try to see, okay, where we draw the boundary, what is the duty of care. But later, after looking at all of these cases, now we have made a legislation where we have made a structured, organized statement as to what a standard of care is. So what does it say? It has two requirements. One, that a director should not act in reckless manner. What does reckless mean? Reckless driving? You know, reckless driving? Yeah. But in a manner that's not following any rules and regulations, right? Not paying full attention, right? Making decisions rashly, not making decisions without proper substantiations, proper explanations, right? So, in a reckless or grossly negligent. There's a reason why it says grossly negligent, because human errors are acceptable. And if it's a genuine mistake, accident, it's fine. Accident in the sense, I mean a mistake in the accounting. But grossly negligent means someone who didn't even properly look into the accounts and just find or made a decision out of it. Okay. So standard of care, the first one is they should not be taking decisions rashly, that means reckless, or they should not make decisions in grossly negligent manner. And the second one is they have to exercise a degree of skill and care that is expected from a person who has the knowledge and experience. Right? So there is a reasonable expectation from a director to have such skill and experience. Right? So even though we say that director should be, the requirement is above 18, I don't think a company would randomly pick a young person without any experience to become a director. Right? Practically, I don't think that's something anyone would do, because they would look into a person with experience, who has the experience, expertise, and skills to make proper decisions. That comes with a lot of maturity, right? So of course there can be some like small startups, everything having like young people, but most of the occasions they will go for someone with experience, because there is not just like a ethical expectation, but there is a statutory requirement that that particular person has to act with certain standard of care. Because if they fail, then they will face legal actions. Okay. Okay, so in re means in relation, okay? In relation to City Equitable Fire Insurance Company. This is a very old case, 1925, and you can see how the standard of care has evolved over the years. So here the court set a very low standard of care, and they said that they had acted, though the company, because of their decision, has gone into a large financial loss. They said they have acted with their expertise, so that's it. We are not going to go for an objective reasonable man standard. But do you remember in the 1977 case, they said reasonable man standard. Can you see the difference? Earlier in 1925, they said the bar is very low, but later the expectation has grown. That's why I have included again that this is no longer the legal precedent. That means this is no longer the law, right? This is to show you how law has evolved over the years. Okay? Very important for you to understand because companies law didn't like it was not created overnight. It took a long process, right? From understanding how corporate functions, how companies function, through case laws, they understood it and finally they made it into a statute, right? So I hope that this is clear, right? Can you see like over years it has increased from low standard to reasonable man standard to higher expectations. Right, let's move to the next case. Slightly a different one, but again, it's also about standard of care. Look at this case. A lucky kid, right? Made the president, and he was 6 months old. Literally, someone who was born with a silver spoon. Even after getting such golden opportunity, he ended up going for one meeting in 38 years. What's happening? A minor who was only 6 months old when maybe his parents decided to make him the president of the company, right? But after he was born, grew up and live a life till the next 38 years, he only attended only one meeting, right? So then the court held that he is not responsible because he hasn't undertaken any of the duties. Because you can see he was nearly there in the nominal position. Do you know the difference between being in a nominal position and active one? For example, in real world, if you take India, for example, they have the prime minister who is the most powerful one. And they also have president. Their president is in a nominal position. They do have some powers, but they cannot make any decisions for the country. Similarly, this person was put as the president of the company without any powers to make any decisions. Just because the company was defrauded by other directors, him being in just paper as the president of the company wouldn't make him responsible for the actions of others. So the court held that he has not undertaken those duties, so he is not accountable for any of the consequences. Next one. Yeah. The question is, it's a very good question because you will actually get a case here. One person is an active one, as you said, the other two people are there, right? But if they possess the competency to understand what's happening in the company, and if they have stayed silent, knowing the decisions made by the director, then they will be accountable. But this minor is not in that question. Even after that point, he only attended one meeting and he was not aware of any of the decisions made by the directors. And you see the difference between the two cases, right? Did you understand the question? There is one active director and if the other persons are just there, he's asking whether we need to find the other two accountable. So staying silent means they are also in agreement with the decisions being made. So if they had any concern, they should have raised it, right, in the meetings. Because though they are not active, they are attending the meetings. They are being informed of the decisions being made, right? So if they just stay silent, that means they are in agreement with this decision. So then if they move ahead with the decision and if that becomes a fraud or if that takes the company to a bankrupt position, then they will also be held accountable. Actually, I will show you that case before we. Yeah. In this one, isn't this a similar situation like you asked? In this case, is there, right? In the previous presentation. Have you? Exactly the situation your classmate explained. Yeah, the other two people are there. But then the question is whether they had the competency, knowledge and skills. Is that clear? Yeah, it's similar to your situation. Yeah. So tell me. Yeah. So they will look into whether that person was competing enough. I mean, like, otherwise, what would people say? I didn't take any actions. I was only here, working as team director, and they could excuse themselves from all the liabilities. So then the question is whether you have the confidence. They were aware and understanding whatever that was happening, or you were just coming to meetings and just listening without understanding anything that's being said or discussed, right? So then, of course, I think this case is already there. Project finance versus study. I think this is the slide that's there, right? I'll get it more instructive so it's clear. I think this is the one that's there in the presentation, the one survey, isn't it? Because I looked at this and I wasn't sure that it was clear. Just the heading is there. Okay. So I think again, I'm making your life easier, but I think the purpose when sir just gives you the cases for you to do some reading and find what's happening in the case. But I have made things easier for you. So I'm not sure if sir wants me to share these updated slides with you. Okay, I think this is an important one. Take note of this case. Okay, just right? 3 members, 1 active, the other 2 had the had the accountants and they had considered the accountancy experience, so then the board held that they are responsible. Okay, this is my way to take a photo. Right. Is that clear? Any follow-up doubts? Did you come across this case before or did you just start that up? Okay. Probably sir must have mentioned. Okay, look at this one. Joey versus Cole. This is an old one. What happened here? The director, though he didn't do any personal inspections or supervision of the records made, he relied on the judgment and the reports that were produced to him by the chairman and general manager. Right? So then later, the court held, since he hadn't had any doubts about their competency, that he will not be held negligent. But you can see this is by further decision, right? You can see the difference. This is an old case, right? But later they said that even if he has relied on that, that means they have the competency to understand it. If someone's relying on a judgment, he cannot blindly pick something, right? They have to understand what is presented to him, and then only they can make a decision. So you can see how the case have evolved, right? Okay. Some of you are sleepy, some of you are hungry, so please go and have your lunch, wash your face, then come back. Do you have lectures till 8 o'clock today? Please go and enjoy your lunch. The different duties of the director, right? So this is another case, right? That is an old one that establishes the principle of having conflicting interests. Okay. So the case was Avadi Railway Company versus Vehicles Board. So it's ruled that a director with conflicting financial interests, that means if he is being a part of a company, being a partner or any other in any other capacity, then the director, he cannot participate in any deals without disclosing such information to the rest of the people, right? So it doesn't mean he cannot be a part, can, but he has to disclose the information. This is to maintain transparency in the company. If he continues to do that, right? If he doesn't disclose the information and if he proceeds to have a contract signed over, then that contract will become null, void, right? It won't be valid. Next one is the case that I just referred is the duty to disclose information, right? So we looked into the duty to act with good faith, to act in the best interest of the company, to maintain a higher standard of care, right? And then we looked into the right or how to use the information, right? How they should use information and how they should function when it comes to matters that they are not experts in, right? So earlier I mentioned in the case of Kevin case, they said that since the other two directors were equal, two of them were chartered accountants and one person had a considerable accountancy background, that they are liable. But if the person doesn't really have that background, then he should consult people who have. He should make his judgment relying on their advice. Okay, so they have to make sure that the decisions are made based on the financial reports and kinds of data that is presented to him. Right? He cannot just randomly make a. That's why I told you, right? It says as he has to personally look into the data and has to rely on the advice given to him by a professional expert. Right? So we looked into good faith, and the other element is he needs to make proper inquiry in events he feels that certain things need to be clarified to him. Certain clarifications must be done. Okay. So as I told you earlier there was one case, right? That since he had more reason to doubt their competency, that the court held the director was not negligent. Right? Do you remember this case? They said, okay, that person relied on the general manager and chairman's judgment and advice since he had no doubt on their things, though it led to a loss of financial profit to the company. They held that the director was not negligent. But now, as I told you, the law has developed in a way where it says it is must that they should get the expert advice, right? So they have to make proper inquiry where the need for inquiry is indicated by the circumstances. That means they can't just blindly trust and believe whatever that is presented to him. Right? The director cannot blindly believe it. They have to inquire about it. Right? And if they don't have any such knowledge, they cannot make any unwarranted decisions. Right? They cannot make any unwarranted decisions. Right. Yeah. It talks about other duties they have. And more than that, we can look into different sets of laws, but I'm assuming since you have made this as a list, that you will not be asked about in depth about each of these duties. But the first 4 duties that we discussed, good faith, best interest, standard of care, and disclosure of information are the ones in which you will be examined, because we have studied case laws for that, right? You can see the difference. Other ones are for your reference, whereas the first 4 ones are the ones we will go in there. Okay, so this one talks about the transactions where a director's interest. If there is a personal interest for the person, we know how he should act. He should put the company's interest over self-interest. And the section 197 talks about the use of company information, right? So disclosure of information talks about some of the information that can be made available to the public, whereas some information cannot be disclosed. They should be maintained confidentially. So the director should make a decision as to which documents becomes confidential and which can be made publicly available, right? And then any disclosure of matters relating to shares that should be clearly communicated with the shareholders, right? And of course, there are duties when it comes to insolvency and serious loss of capital. These are just something that you have to remember, but in depth, look into the previous duties that we discussed in detail. Okay, so this topic is included, maybe I believe it's for the reason that you understand how the law functions. So until at this point, we looked into different sections from the Companies Act. If I say it's from the Act, that means that is a law, and if someone breaks that law, they will be punished, because it's an offense to break laws, right? But corporate governance is not functioning merely with laws. There are some practices, code of practices, code of ethics that are being followed, but there is no punishments if you don't really follow that, right? Because corporate governance is a very broader concept, okay? So if you look at the way how corporate governance evolved over years, back in the time, it was handled by the entire private sector, and it was so widespread and diverse. So there were no proper common mechanisms to handle that or operate this whole corporate. Why? Because the government, if you take a government sector, if they want to bring in a law, they can immediately send a circular, and it can be sent to all government departments, and it's applicable. Why? Because it comes under one umbrella, right? One head of state, and then that covers for the entire government. But if you take the corporate sector, it's so diverse, it's handled by so many people, and it is completely given to the private. So that means the influence of the government cannot be at all the time. It cannot influence every single decision that they make. So that's why you would have observed from that time to this time in the corporate sector, so many issues related to harassment, right? Harassment, issues related to minimum wages, issues relating to the working hours, maternity leave, etc., etc. So many issues have been raised. So imagine, very recently, you all must have seen that non-academic staff went on for a strike for how many days? 75 days, right? Do you think that's possible for someone to do that in the private sector? With the corporates would be patient enough to let them go for strikes? No, because the reason is they run on the profit and loss mechanism, whereas the government sector is a service-oriented sector. And more importantly, in our constitution, we do have given them the right to freedom of assembly, right to expression, right to etc., etc. So when they go for a peaceful assembly and asking for their demand, we cannot really do anything about it. But when you come to the corporate sector, that's not how it functions, right? It has very strict way how it functions, and not many rights, I wouldn't say all of them, not many rights are protected in that spectrum. So that's why the whole concept of corporate governance was introduced, to make sure that the people who are working, who are involved in the sector, are protected. So all this time we were talking about people who are at the top level, right? Directors, shareholders, all of them. Even for them, we are thinking about how their rights can be protected, when they will be sued, etc. So imagine the people who are living and working in the lower tier of this whole corporate sector. How are their rights going to be protected? So that's why they introduced this concept of corporate governance. Although the companies are so diverse, they have different mechanisms, they function differently, there needs to be some common basic standards that should be maintained at the bare minimum. For example, they all should be given the maternity leave policy. If you take Sri Lanka, maternity leave policy is common for everyone, right? Private sector, banking sector, government sector, all of them. Of course, I think in government they can go for no pay, half pay, but that's not available. At least the basic one is given, right? And again, the next one is sick leave, right? Earlier there weren't any sick leave, but then they introduced the sick leave as a common one for everyone. So you can see how labor law has evolved and how the corporate has slowly incorporated this. And of course, based on any recruitments that's done based on discrimination. If they discriminate women or any disabled people, nowadays they have a say, they can question, right? And more importantly, for example, if there are any sexual harassment that happen and if that is reported, they can have a recourse these days. But back in the day, they didn't have any such mechanisms to get protection from. So you can see how corporate governance has evolved. And this governance is, of course, it's one of the responsibilities of the director. It is their duty, but it's more of how the whole system functions. So you can see that Companies Act, as I said, Act, when it comes to a statute, they have a legal obligation, a statutory obligation, and if you breach it, it is fine, right? It is punishable as an offense. But there are other institutions which introduce good codes of practice that comes examples for corporate governance. Are you familiar with these institutions? Institute of Chartered Accountants, Institute of Audit Committees and all? Do you know these institutions? So these institutions are not government, right? So they are private institutions, so they cannot have too much influence on how a company runs. So what they can do is they cannot introduce law because the government only has the power to make law, right? So what they can introduce is codes of ethics and codes of best practice. So the fact that it is a code, that means that even if you don't follow it, no one's going to punish you. But it will affect your status in the business sector, right? It can affect you. So this can be for many reasons. For example, if you take an example of being punctual, right? So being punctual, can a company punish you for not being on time? No, but of course, if it's a then if it continues and it becomes a behavior pattern, then they can do something about it. But at the point, it's a code of ethics. So that counts as a disciplinary mechanism. Similarly, showing up for me, right? No one can punish you like put you in the prison or fine you for not going for a meeting. But what they can do is they will say you are in breach of a code of ethics. So they can have a disciplinary meeting against you. So all of these hidden things, indirect things that affect your business. For example, reputation. One reputational risk is there is no such like particular laws that would say that you cannot. Of course, you have freedom of expression. So there is one law would say that you cannot make any statements about X and Y. But within the corporate sector or in advertisements, even in ethical advertising, they will say you can make an advertisement, but you cannot make an advertisement in a way saying our product is better than the other product, because that is an ethical requirement. Of course, healthy competition should be maintained. Fair competition is a law, but there is a layer of ethical protection that is expected from you. Right? So corporate governance is more about the ethical part. Okay. So corporate governance, I'm not going to spend too much time because that's just about the best practices. So we do have a mandatory code of corporate governance that talks about disclosure of information, independence that should be given to the members of the company, and how remunerations must be. Remuneration is payment should be given to the people who are part of it. That we should not just get free labor out of people who contribute to the company. So the law will not talk anything about this because it talks about your duties and the powers you have. But in addition to that, if it wants to get some protections, then you can go for the code of practices, right? So that's all on corporate governance, and from here we will move to the next topic. Right? Any questions on corporate governance? Anyone? No? All right. Next section. First, we will be looking into promoters, and then we will move to the next topic, space plan. All right. So, do you know who is a promoter? Yeah, because I don't think this was scheduled for the latter date. I think, when is your exam? After the vote, right? Probably you will have them completely. So I think you need the accounting reports presentation. This one. You already have rector's duties. Right? Okay. Winding up session. They have proposed. And the lesson is not done. That's the regular activity or but anyway, this is in your syllabus, so we need to do that. Okay. I don't yeah, let's think. So I have sent a couple of questions, but these are clarifications. I don't think it's nice for me to ask too many questions at a time. So I asked a couple of questions. And sir, I think the administrative department also tried to contact sir, but they couldn't reach out. So I will arrange for that. But I will try my best to send the presentations to you before the lesson, so that's easier for you, right? Yeah. All right. So let's about promoters. Any idea who a promoter is? I'll have to check if that's the thing. But I will try my best by next week and hopefully you will have it. If not, I will send a link here so they can upload that to you. Okay. So any idea who a promoter is? No? This lesson is actually what happens. So until this point, we looked into how a company functions, right? Meetings about it. What else you learned before I came? Different types of companies. You learned about major transactions, how it's done, how a director should function, right? You learn a lot of things about company, right? So this lesson is about what happens before a company is created. What comes before that? Any idea? What comes before a company starts? As I told you, a company is not something that starts overnight. So what do you think? Do you know what happens? Like the process and how a company is, how to start? Any idea? Yeah, registration comes afterwards because once you have everything prepared, your articles of association, you have the number of people, you have the directors, all of that goes with registration. But what happens at the beginning is you have promoters, right? So who are these people? So promoters is the person who has this vision, who has the idea to start a company. So they are basically the ones who is there since the inception. They are the ones who go out and seek funding. They go out and basically promote the idea. We have an idea, we have an objective to start a company, and these are our ideas. This is how we want to function. This is how we want to collect money, etc., etc. And then they get investors. Right, that's how a companies start. So even if you look at the small startups like IT companies, they would say they get investors, right? So for example, they will say for an IT company, they will say they get a client. If they have an idea, for example, if they have an idea, let's say for LMS, right? LMS, you have to move the app, right? Yeah. So imagine they are at inspection, they will say we have a vision, we have an idea for an application that will administer all student activities. It has this feature, but they only have like a surface level idea. And they will first sell the idea and they will get investors. Have you watched Shark Tanks videos where people go talk about their companies and Shark Tanks videos? Have you seen? Never heard of Shark? Like where investors sitting and you go and like present your ideas? Yeah? Okay, a couple of you. Otherwise, it will look like I'm talking about some nonsense. So, Shark Tank, you can look into. So, basically, what it says is, yeah, investors are this up and you have an idea, but you don't really have the money. What you do is you go in front of them and you pitch your idea to them, right? If they like it and everything, if it works out, they will invest on you. YouTube videos of them. Do they have a version here in Sri Lanka? Shark Tank, yes. I have seen the ones from US and India, but do we have one in Sri Lanka? Yes. Right, interesting. Good. So basically, how you sell your idea. You have an idea, you pitch that, and if investors like it, they will invest on you. Okay? Right. So that's who a promoter is. But it says promoter is not something that is defined in the Companies Act, but it's basically someone who takes the first steps, necessary steps to build the company. Right? So now we are going to look into a case law. This is a very old one, as you can see, where the concept of promoter was discussed in a court of law, and where we learned about it, and where the court finally gave a legal definition to promoter. It's not in the act, but it is in case law. Okay. So in the case of White Cross versus Grant, A shareholder sued the company's promoters for failing to disclose certain contracts in the prospectus. So prospectus is the document that publicizes first by the company. It's not the articles of association, right? It is the very first document where they sets out the objective, their ideas, and they send that to the investors to have an idea. So have you seen prospectus of universities? Like a document where they will say we have these courses, benefits like this and all. Have you seen prospectus? So basically that's the idea. That will not give you all the details. It will only give you like a framework idea. Okay, this is what this company is about, right? So what happens is these promoters, they have disclose the information about some contracts in their prospectus. Very important contracts, but they haven't included that. So later, they committed fraud and they have intentionally omitted. That means intentionally, by willfully, they omitted to include those two contracts in the prospectus. So then the court held, since that the fraud was committed through that act, that it makes it the promoters accountable. So here only the court made a definition as to what and who a promoter is. Right? So it defines as one who undertakes to form a company and set it going. That means the one who initiates it, that start the company going. And though the company itself couldn't be held liable for pre-incorporation contracts, means before the company starts, if you sign a contract, that is pre-incorporation contracts. We will learn more about it later. That there is an implied duty for the promoter to be transparent, because you cannot cheat your investors. You have to be transparent with the investors. You have to disclose all the necessary information, because they are the ones at the end of the day who is investing in your company, right? So you cannot defraud them. So you have to give them all the necessary information. So since they haven't acted with such transparency, the court held that the promoters are liable because they should have incorporated the important contracts that they signed in the prospectus. So you cannot go ahead and tell someone, pitch your idea, tell you about your companies, and later only the investors realize that the particular company has some negotiations and have some contracts with other third parties, that comes to in conflict, right? What if that people don't want to work with them? So that is actually hiding some information, important information. So you cannot do that. You have to be transparent as possible. That's what this whole case is about. Okay? So basically, who undertakes to form a company and takes necessary steps to accomplish that particular purpose. So as long as the work of formation continues, those who carry out should work until that point. They have to retain the character of promoters, right? Until it is completely formed into a company, becomes a registered one entity, the promoters have to be part of that. Okay, the moment they just pitch the idea, once it's done, they cannot leave. They have to make sure it is fully accomplished the task of becoming a fully fledged company, right? So in very colloquial terms, for our understanding, we can consider promoters as the parents of a company, right? Parents of a company, right? So here the section says promoter means who took part into the preparation of the prospectus. As I told you, prospectus is the very initial first document that is sent out to the investors. So if that particular document contains any untrue statement, that means false statement, right? Any false lies, false statement, then they will be held liable for their mistake. That is a civil liability. That means that in a civil suit, if it's filed, they will have to pay compensation, right? That means you cannot be part of an untrue statement. That's what the promoter's role is about. Okay. So who can be a promoter? As I told you, since there is no strict definition as to a promoter, these are all emanating from different case laws. Okay. So, who is a person who is a promoter? It can either be an individual or an already established corporation. Corporation can come and present an idea for another one. Okay, it doesn't necessarily have to be an individual. Because you all know, right? A company is a legal person that can be sued and can sue another individual or another company. So that an incorporation can also present idea. Of course, it will be human beings, but they can present idea on behalf of the company. Because you must have seen, like, companies having other companies in their names, because that's how they branch out and they and their business. Okay. But if a person is a mere servant or an agent, then they will not become promoter of the company because they have different terms. Did you learn law of agency? You guys skipped legal environment, like the first batch, right? Do you know the difference between agency relationship? Yeah. So agent is basically someone who is representing us in another occasion, but doesn't mean that that person can be held liable as a promoter, right? Okay. So these are a couple of examples. For example, if you want to come up with a company, you will go for a prospectus, and of course, it's reasonable to assume that you will get some legal advice. Just because an attorney gives you a legal advice, that lawyer will not become a promoter. He is merely an employee who is helping you. That's it. You are having a contract with that person to help you with the task. That's it. He is not a promoter. Similarly, if an accountant comes and helps you with initially set up the company, then that person is only there for that particular task. Once that's over, there is no connection between that person and the promoter. The promoter stays as the person who had the first vision or the idea to come up with that company, right? The one who works for it. Right, that's why it says parents of a company. Okay, so the promoter has fiduciary duties towards the company. Do you know what fiduciary means? That's me. Trust kind of relationship. They have the expectations of a duty that you will have from a person whom you trust. So that's not a legal obligatory duty, but a fiduciary duty. Similar to a one that a child will have from their parents to feed them properly, to take care of them properly. Similarly, the promoters are treated as the parents of the company. So they will be expected to show that fiduciary duties toward them. Right. Have a look at this case. Again, it's an old one, but it's still relevant. You could just remember this one, that's sufficient, right? If the prospectus, right, that the document failed to disclose the information about the promoter's profit, what the promoters will get out of that particular company if it's been invested by someone else, then the court held that they have to be held liable because they have to disclose that information openly to the public, right? So you can see that the promoters stand undoubtedly in a fiduciary position. That means they have to disclose such information because they have in their hands the creation and molding of the company. They are the ones who are creating, right? So when they put about this idea, the idea for the company out there, they have to tell the world what they are getting from it. They cannot secretly hide it and then tell them, this is the idea, you have to invest on it, right? So that's what it says, because it's unjust for promoters to use their effective control over corporation to exploit whoever investors that come in to invest them. And so promoters first is basically someone who is there in the initial stage. That's the first understanding, right? And secondly, they are the ones who are treated as the parents of the company. And now we are looking into how their duty extends to the people that they interact with. So when it comes to investors, they have to be transparent. They have to disclose all the necessary information to their investors. Right? That's the primary duty here. They should not make secret profit. Right? They should not make any secret profit. That means they should not disclose an information and then get benefit from it. And they have to make disclosure of any profits that they might make. So it doesn't mean they cannot make any profit. They can, but they have to disclose it. Okay? So basically, promoters have a duty to disclose their interest and conflicts if they have anything. All right. Okay. Look at this one. So this is about purchasing a coal. Yeah. Do you know what a syndicate is? Any idea? It's basically a set of people who combine to come together to. Wait, isn't this something that you have movies syndicated for like for one objective they form people usually that's used in like hubs or people like they form syndicate to attack some places. So usually it's basically someone who comes with some common objectives and work together. A syndicate had purchased. So basically let's say a set of people or a group of people who have like same visions or objectives. Again, right, they have failed to disclose a profit. So that's why I made sure that the keyword is highlighted for you, right? Similar to here, they have failed to disclose the profit that they will be making. Here also, they have failed to disclose the profit that they will be making. So the court again stressed that if someone fails to inform that, then that is in breach of their contract. So they can rescind the contract. Imagine promoter is there, they're going out, sending out their prospectus. A couple of investors are coming forward saying that they are interested in this company and they are investing in it. They are signing a contract, and later on, they are realizing that the promoters are making a secret profit. And then what the court will say? The court will say that the investors are entitled to recover the profit back because they were not disclosed about this information at the beginning. Okay, so that's the idea behind this. So, what are the remedies? That means, what are the solutions they have, the investors have, if that there is an attempt to get secret profit? One thing is they can cancel the contract. Okay, they can say we no longer want to work with them, right? Because they were trying to make a secret profit. They can recover that profit from the promoters. That means the money that they paid as investors, they can recover that. And they can, in addition to that, can claim damages for breach of fiduciary duty. Do you know the differences between these two? Because recovering secret profits means they can recover back the money that they put in. Okay? In addition to that, because they have invested their time, right? They have invested their energy, they have made a decision, maybe they must have made some own like declarations that they are taking up this company, etc. And now all of that has gone into vain. So then, in addition to this amount, you can go for damages. You can ask damages from the promoters, right? So even in a normal contract, let's imagine you sign a contract with a company for a particular amount, but then they defraud you. What you can do is, first, you can ask that money back. In addition to that, you can ask saying that you have suffered emotional distress because of the defraud. You have faced reputational loss. You have lost your name in the business market. So you can claim additional damages, compensation for all those losses, right? So first thing is you can cancel the contract. Second thing is you can recover the secret profit, whatever that's been collected by the promoters, and then you can go for damages for the breach of fiduciary duty because you have trust in them. So that deals more with the emotions because you had a trust, you trusted them, and only because of the trust you went ahead and signed the contract, but later on you were put into defrauded. You were defrauded, so you were basically cheated. So if that's the situation, then you can go for damages. So those are the remedies. Remedies mean solutions. Anyone want tea? No? I'm not a big fan, so. So then the question arises whether the promoters should get a payment, whether they should get a payment because they cannot get secret profit. That's what we are saying, right? They cannot get any profits. So then the question is, they have put up a lot of work into the idea. They have put so much effort into coming up with this fresh idea, right, for this company, and they have worked so far. So now the question is whether they should be paid. I mean, it would have been nice if all of you had watched Shark Tanks because Shark Tanks, they will explain, right? They will ask for 5% of the company and they will say, we will only give you 95%. Then the question comes, at the end of the day, they will become the main owners. They will only be part of it for a very short time. They don't want to lose. So please go and watch Shark Tanks, right? It's a very educational video for you to check out. Basically, how you impress an investor. If you have an idea for a startup or a product that you want to sell, right? So then the question is whether you should pay for a service that is being provided by a promoter. So the answer is no. No right of remuneration means fee, right? Because they are considered as the parents of the company, so they cannot really be paid. But what they can do is, if there is an article association included, because they must have spent some money, right, at the very beginning to go and meet these people, maybe transportation costs, they must have spent some amount of time, energy to prepare the prospectus. So all of those things can be compensated back. They can be repaid back, but they cannot get a set of sum, okay, because you worked on this, you cannot just have. So this is what happens to many startups. What they do is they will have a really good idea, they will have a company, but they will not have the capacity to expand. So all of these big corporates will come and sit. They will say, we will amalgamate with you, we will operate you with us, and they will become the big master. So this has happened a lot of things. Recently also, you know, WSO2, the software company here in Sri Lanka, the biggest one, that was incorporated by a foreign one. So some said it's good for the company, and some said like that's actually showing that Sri Lanka has some power. They notice the potential. They know they cannot afford a lot, so they just came and take it. So that's how these big corporates work. They try to take these small ones with good ideas, and then they make it their own. Because a lot of companies, group of companies and Reliance companies, there are so many other companies, if you notice, they didn't come up with all of that ideas. Because they must have started with, so recently you must have watched Ambani's famous wedding, right? All watched Ambani's son's famous wedding. So Reliance company, so their basic idea is, they started with oil refinery, but nowadays they are having so many different kinds of business. So it's not something they started investing and they don't really have the expertise in each of these areas. So what they do is they observe the market. They see who are doing well and they just accumulate them. They get them into that and they become the biggest shareholders in this company, and those companies will get a set up amount. Or some companies, they sold the entire company to these big corporates for a big lump sum money. Right. So now question time. After lunch, looks like you guys are more sleepy. All right. I will sum up, of course. Okay, so now tell me one of you, who is a promoter? Looks like you guys are in the selling, which is good news. So what are the duties of a promoter? Entering into contract, but before that, we have to reach out and get who? Investors. So basically grabbing investors in their first, because they cannot really function. If there are, so I think that's famous for the that 100 people can come up with 1,000 millions of different great ideas, but it takes a lot of efforts to make one of them a proper company, right? So it's very important that you get the right kind of investors, right? Okay, so now explain with reference to case law. So this is how a legal question would be. How will you do that? Since you haven't done any law papers before, right? This will be your first paper. So probably the question will be like this. What are the duties of a promoter? And you'll be explain that using cases. So then how can you do that? So if I were to answer that question, I will say it's the duty of a promoter to disclose all the necessary information to the investors, and they should not make secret profit. And then I will cite the cases that's given here. Probably I will have that in my mind, but yeah. And so my answer would be first, I'll go this. So if I were to ask who is a promoter and explain your answer with reference to case law, then I will go with this, right? I will say promoter is someone who undertakes it, periodically leads it, and then I will cite the case to Cross versus Grant. But if I'm asked the question, what are the duties of a promoter? And then if I'm asked, explain with reference to case law, I will go for this case, right? Which says that I have to disclose information. A promoter has a duty to disclose all the necessary information to the investor, and he should not make any secret profit. Then I will cite the case, versus New Phosphate Coal, right? If you couldn't remember the whole thing, just write the phosphate was something, right? Something that you could remember. Similarly, you can cite this case as well. This is easier for you to remember. Right? Same versus parts. Or at least if you couldn't remember the first name, just write a case against Barnes. Right? Something like, or at least if you couldn't remember anything, say in a decided case relating to purchase of an exhibition hall. Right? Just try to tell us that you know the case, because that's what the markers are looking for, right? So tell us that relating to a case relating to purchase of exhibition hall for Olympia, the company failed to disclose about the profit that they were making. The court held that it is their duty to disclose all the information and they should not make any fix. Right? Is that clear how to answer a question? Yeah. What are the remedies available if the promoters of the company breach their duties? Yeah. Sorry. Yes, first one, cancel the contract, and then yeah, recover and damages the breach of duties. All right. Very good. Give me a second. Have five altogether. How many lectures? Three. For each like subject, we need 15 class. Do you have any academic calendar? I don't have used that. If that's the only one, we only have one more. But one has to be completed. We only have yeah, meeting speed is there. This is the whole thing. That's all. So the I don't have this presentation here. Sorry. Yeah. Sorry, directors, we should not this one. The lessons you have covered is different from the one. That's the only extra one, right? Really? Yes. You want to prefer that? design. Other institutions are usually prepared by they take questions from like say professor technical system pattern, so they make sure it's not part of the on there are so many private universities. But this part I heard. Nothing from this subject. Different papers. And they pick the question, and I don't think they will be that. Could we have the meeting actually? I think it'd be a good idea for you to practice the paper because you haven't done legal environment. Like, no idea how to answer law paper. Better if you could practice. Do you want to maybe like try out a question? So I can. You all have access to the past papers, right? So if you want to try out a question, 2022. We want to try that out and use it. Access to past papers, right? Papers. So just like how we discussed now, we can discuss answering methods. That's because we only have pre-incorporated company contracts, which can be completed in an hour, and one more one that managing director, and then binding up. That's all that I have. I understand that you're still. So, can we look at past paper? Did any of you like looking at the past paper? It's your paper, right? There's a question for insurance. It's a mention that you have insurance too. Maybe it's a previous class. It's this is not yours. But how it is done is see. It's open. Okay. So do you all have access to your past papers? Which website? Is it publicly available or only for these one paper email and paper? Because I don't have access to Ireland.
Can we use company law?
Questions? So for this paper, the instructions is yes, you can.
For reference.
Your final exam. Your final exam. That's it.
For company.
No, that's why I'm asking. This is our exams, no, we're gonna allow to do. But since you are accountants, specialist, because you're a specialist, not law, right? So I'm not sure if they will allow it. But it's the instructions. No instructions. But I'm not the cases, but I know you for the cases. Then I'm going to the cases. Those papers and all that was like really a standard. These are like really easy questions. And I don't think you should need the companies that. Yeah, explain any four of the following, and it gives you incorporation of a limited company, majority rule, types of shares, the incorporation practice. You can write 5 sentences about each of them, right? Do that part. Isn't it?
Yes,
Okay. It doesn't. Okay. Did you look at the chart for the paper? That's like super hard, right? Because that's really tough. I was thinking like that's the level of difficulty. So I was watching. Yeah, it's a one group. Yes. Then I understand. Yeah, that's my name. So distinguish between a partnership firm and a company. Partnership and company. That's like they change the commerce quickly. But I have this difference between a partnership. 7 marks. You can do this paper really. I don't think it's at all a problem. If you want to do a paper and see the answers. If you want, what we can do is you all can try to attempt one of the paper and we can discuss that. Okay. Do you want to try the paper? Depends on the time. It's actually simple. I'm gonna do the company contracts because that's the small lesson, and then we will do pre-incorporation and winding up on next class. Okay. Then open book, but I don't think they will allow them to bring their case. Only the companies. All right. Okay. Company contract. This is just a basic idea for you guys on the law of contract, right? So, do you know how a contract is formed? Okay. So, what usually happens is first an invitation to trade, right? That is sent out. So, if someone wants to, let's take an example of tender hold, right? You all know, right? For construction, they call tenders. So what they usually do is they say that this particular project is available and people can submit their offers, right? Once the offer is accepted, that becomes a contract, a legally binding contract. That's like the very basics of a contract. Okay, that's clear. An invitation to trade will be sent out. People will offer back their offers. They want to get it for this million rupees, another will say this million, and the lowest bidder will get the project. And once that is accepted, that becomes a contract. So there can be so many different kinds of contracts. So example, in domestic terms, a friend can ask you, come to let's say today you all had like a birthday party plan, right? So you all came into an agreement. And you all decided, okay, on this day, on this time, at this place, we are going to celebrate the birthday. Right? So that is a domestic agreement that has no legal enforcement. So if one of you didn't go to the birthday party, do you think others can sue you? Others can file an action in the court? No, because it's a domestic contract. But once company becomes a legal person, any communications you have with the company will become a legally enforceable agreement, right? It's no longer because it has passed the level of being just a mere domestic contract. So company as a legal person can have contracts. I, as a natural person, can have a contract. I am a legal person. Similarly, a company can have a contract. It can sign a contract. It will have the terms and conditions upon it. So both parties have to abide by it. That means they have to accept and proceed as what it is said in the contract, because it binds both of them. So if you take a contract of house renting out house, the tenant as well as the person who gives the renter, both of them have responsibilities. Both of them, it binds both of them, right? So that's how contracts are formed. So if you look at company contract, they come into an obligation because see, if it was entered into by a natural person, we consider company as capacity to enter into a contract in its own name, right? That's clear, right? It's a legal person. It can enter into a contract of its own name, right? It can be in writing and signed, and of course, who will sign the document? Can the company come and sign? No. Then, yeah, right. Their representatives are the directors. If two directors. If one director, that director has to sign. And if the articles of association have specifically allocated a person, in some companies they allocate different purpose for different companies. Like I think for accounting purposes, they will have someone to sign any documents related to that because they can't have the directors for every single one of them. So if it's of minor importance, then it will go for people who are in the lower layer of the hierarchy, whereas if it's of serious importance, it will go to the directors, right? And it has to be notorially executed, and they have to have a attorney who executes any deeds, because companies can buy, they can sell properties because it's in their names, right? So you need to bring in all these people who are responsible for it. So that's basically the. And also another important element of contract law is in Sri Lanka and also in English law tradition, we not only recognize writings, we also recognize oral contracts and implied contracts, right? So contracts that are spoken by words are also considered as contracts, right? So imagine in like paddy fields and all, you get laborers to work for a particular period of time, right? For seasonal laborers who come and work in a paddy field, you don't really have a labor employment contract with them, but you have an oral contract. And if you fail to pay them, they can go to court and say, you know, I have worked for this many days, for this many hours, and they promised to give me this payment, but now they are refusing because oral contracts are valid. And similarly, we also look into implied contract. Implied contracts mean there is no express statement. That means, so imagine in a company, usually the master, like the person who is the boss, he usually do all kinds of transactions. And he makes sure he gets the goods loaded, he kept it. But he always had a person who was responsible. So whenever he goes to lunch and all, this person sits in the cashier and he deals with the transactions. So then if a person comes and pays to this, let's say, second shopkeeper or whoever, there is implied understanding that this person will function in place where that the main boss is absent. Right? So that is implied. No one has to orally say it. Like in the shop, they don't have to write, if I am not here, he will be responsible. Or he doesn't necessarily have to say out loud. He doesn't have to say that if I am not in the shop, he is responsible. It is implied through their conduct. Through the way they conduct themselves, you can assume that this person has the responsibility. So that's how implied contracts are formed. Right? So first one is express. It can either be in writing or orally. And the next one is implied contract. That applies to companies as well. Okay. Right. So the company the contract in writing, orally, that can be through express or implied authority. Or if they have a tradition of continuously attending a particular event, or if they have continuously doing a particular practice, then that means we will have a legitimate expectation that that person will have the authority to function as such. They don't have to say it out loud for a long time. That's what the practice means. So through their conduct, you can imply that. That means you can derive it. You can assume that. You can understand that through their conduct. Okay? So those are the elements of company contracts. But I'm not entirely sure because contract law, you didn't have like the basis of contract law. That's like one sort of lesson that's for the legal environment. So if you have any questions specifically for contract law, just let me know, right? So I can ask her and you can maybe have a tutorial on just law of contracts. But it's company contract clear, that is a legal person can enter into a contract. It can be either expressed, it can be in writing, it can be orally or through implied, right? So that's like just for company contracts, because law of contracts is like a separate lesson if you want to go to the next step. But that's not in your syllabus, so I'm not going to get into that. Okay? Any questions on contracts? Then if time permits for you, because you all are working people and I understand that you are busy, but if time permits, have a look at the March 2024 paper and try to write answers to that. In the classroom, we can discuss. Okay? In next class, we will do the lesson you sent, right, on auditors and accountants, the duties and responsibilities, and then we will finish up with one unit. Thank you. Do you also have tutorials or just lectures? We have separate set of tutorials. Yeah. You mean the presentation? No, I'm asking tutorials in the sense like, so in universities, they have lectures and they also have tutorials. You don't have that. But the science sheet has tutorials, right? I'm asking about this. This one? You don't have that for any subjects. Yeah. Yeah. They have. It's exactly the same. Other subjects, do you have tutorials? As in addition to the, so in the lecture you will have the regular syllabus and in tutorials you will have paper discussions, activities. All right. If you have any such, it can be, but if not, that's fine. We can cover up the syllabus by next week. Right, thank you.